Good afternoon, everyone. Thank you so much for joining our webinar on the new labor codes and the implications of those on the compensation structures and actuarial valuation of employee benefits. Taking this webinar will be myself, Kushwant, and Shurbi. I hope you would be aware, being our clients or our audience, as to who we are. We are Actuarial firm who specialize in design and valuation of employee benefit schemes. And given the new labor laws, we see material impacts on compensation structures and our liabilities. We thought it's a good opportunity to share our thoughts on the new labor codes. As house rules, this webinar will be for 1.5 hours. We have structured our talk to last for about an hour and 15 minutes, leaving 15 minutes for questions. You all have a chat option or a message option. We request you to keep putting in your questions so that we can answer that at the end. In case we are not able to answer any question at the end of the webinar because of paucity of time, rest assured we will get back to you with our responses on your email addresses. We, of course, have your details. Go to the next slide. This is how the presentation is structured. We'll be starting with the introduction to the labor laws, basically what is the history and what got us here, and we'll clarify where do we stand today. The laws have been notified, rules are awaited, but actually on ground, what do we need to do? We'll clarify that situation. From there on, we will move on to the key changes impacting compensation structures and actuarial valuations. Now, there are a lot of changes that are coming through these labor laws, but one of the biggest ones is around compensation structures, the definition of wages. We have all been debating it, and we'll try to do a bit of a deep dive into it. Thereafter, we'll talk about the potential impacts on both your balance sheet liabilities as well as your ongoing costs, and then what is the best way forward, in our opinion, that an organization can take to implement these labor laws. Of course, all of this from the perspective of compensation structures and actuarial valuations. That is the limited scope for this webinar. Before I go into the presentation, a couple of standard disclaimers. We are not lawyers, we are not labor law consultants. We are sharing our opinion as to how we feel these codes can best be implemented, right? What we will be sharing will be generic assessment and not any client specific advice. So please keep all these things in mind as we go through the contents of this presentation. Next slide, please. Okay, just to give you a background, as you may be aware, labor is a concurrent subject in an Indian constitution. So both state governments as well as central government can make laws around governing labor. And over a period of time before these codes came in, there were effectively over 100 state laws and over about 40 central laws that were regulating labor in areas such as industrial disputes, working conditions, social security, wages, etc. It became quite complicated. It was then that in 1999, sorry, it's a mistake over here, that the then central government appointed the Second National Commission of Labor, which submitted its report in 2002. In its report, it found the entire labor law structures to be complex with archaic provisions and inconsistent definitions. And it recommended consolidation of central labor laws into groups. Into what groups? That's mentioned in the last bullet on the page, into wages, industrial relations, social security, and occupational safety, health, and working conditions. As a result of this work, in 2019, these 4 bills, these 4 codes were introduced in the parliament and were passed, but they were not notified. We can move on to the next slide, please. As on 21st, so I do recall going back to 2020, 2020 and 2021 that there was a lot of discussion around labor codes, but they were not notified, they were not implemented. But as on 21st November 2025, the government has notified all the 4 labor codes. Remember, these labor codes actually subsume 29 out of the 40 central labor laws. These codes have been notified, and in our opinion, now there is no question of can we avoid it. In fact, with the notification of these, labor laws, 28 out of those 29 that are getting subsumed into these 28 laws out of the 29 that are getting subsumed into these codes have been repealed, right? So those laws 28 have been repealed. Only EPF Act continues to be enforced for the time being. I understand that the central and state rules are awaited, but in the absence of those rules, existing rules continue to apply. A lot of clients, have come back to us asking, are they effective now? Can we wait for rules? Can we wait for next quarter? Various kinds of questions have been coming. In our view, codes have been notified. There is no question of being able to avoid it now. The only question that we have is, how can we absorb the impact responsibly? There is no wait for rules window that exists for us, because till the time new rules are notified, the existing rules continue to apply. Going on to the next slide, please. Okay, so there are 4 codes that are coming in force, that have come in force. One is code on social security. This is the list of all the laws that it subsumes. We've kept the PF1 in pink because that is one which still continues to be in force and has not been repealed. Rest all others have been repealed. I'm not going to name all of them, but the most important ones are the Gratuity Act, PF, Employee State Insurance Act, and Employee Compensation Act. All these 4 get subsumed into the Code on Social Security, apart from the others that I mentioned here. Next slide, please. Code on Wages 2019. Previous slides will be. Yeah. This subsumes the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. All those 4 stand repealed, and the Code on Wages is now in force. The Industrial Relations Code subsumes the Trade Unions Act, the Industrial Employment Standing Orders Act of 1946, and the Industrial Disputes Act of 1947. Going on to the next slide, please. This one, the Occupational Safety, Health and Working Conditions Code 2020, that subsumes a lot of these laws. I'm not going to read out the list, but all of these stand repealed, and our OSHWC code stands in force today. Moving on to the next slide, please. So before we go into what impacts compensation structures and actuarial valuations, I want to make the position absolutely clear. The codes are in force. The definition of wages stands applicable today. If you are doing any gratuity settlements after 21st November, they need to be done in accordance with the new laws, in accordance with the new definition. Of course, we hear companies, right now settling on old basis and giving letters to employees that we will, we are in the process of implementing laws and will give you the differential. Those practices are existing, but from a legal standpoint, as we understand, and we have spoken to a few labor law consultants also, these laws are in force and the new definition is in force, and the benefits have to be paid on the new basis.